For years, the conversational AI industry operated in an unregulated void. Companies launched experimental models and gathered millions of users, while the industry waited to see when and how the government would finally write the rules of the road. That silence ended when the U.S. House of Representatives held the first federal chatbot-for-minors floor vote in American history. They passed the Safe Bots Act, a bill that makes it illegal for a chatbot to claim it holds a licensed professional medical or therapy credential when speaking to a minor. 24 hours after the roll call, Wired published a leaked internal spreadsheet from Meta containing 3,748 rows of testing data. The document revealed that Meta contractors had spent 8 months posing as minors to run 45,000 crisis prompts, including images of pills, knives, and nooses, through rival chatbots from OpenAI, Google, and Character AI. The spreadsheet documented contractors successfully provoking the exact medical and therapeutic claims the new federal bill had just outlawed. While Congress was voting to ban the behavior, a Fortune 100 company was already documenting it happening in the field. The collision of these two events, a federal floor vote and a documented data leak, shows that the regulatory landscape is no longer hypothetical. The evidence of the behavior arrived on the same day as the statute designed to stop it. In a federal court in Illinois, OpenAI is facing a lawsuit for the unauthorized practice of law. In its motion to dismiss, the company is asking the judge to rule that ChatGPT is, quote, not a person, but a tool that relies on statistics to predict the most appropriate sequence of words. While that case is pending, the city of Baltimore has filed its own suit. They are targeting Grok, alleging the model generated millions of sexualized deepfakes in a 10-day window, violating the city's consumer protection laws. In Santa Clara, a former safety engineer is suing xAI, alleging he was fired for raising internal concerns about these very same risks, just days before he was set to present his findings. And in Florida, a widow has sued OpenAI, alleging a user engaged in 16,000 interactions over 18 months to help plan a fatal shooting on the Florida State University campus. These cases all wait on the same answer from the federal bench in Chicago. Because the Illinois motion is the first serious test of the tool defense, its outcome creates a citation that every other pending AI safety docket, from Baltimore to Tallahassee, is now waiting to read. But the courts are slow, and executive agencies are moving faster. In June, the Department of Commerce issued a sudden 19-day kill order on Anthropic's Fable 5 model, citing national security concerns after researchers discovered it could produce exploit code. Commerce Secretary Howard Lutnick restored the model not through public rulemaking, but via a private compliance letter. In exchange for the restoration, Anthropic agreed to help the government develop security standards and report malicious activity directly to federal authorities. 7 days after that deal was struck, Anthropic began requiring a subset of users to prove their identity with a government ID and a live facial geometry template to continue using the service. While individual secretaries flip these switches in Washington, the states are filling the gaps. The federal Safe Bots Act explicitly refuses to preempt stricter state laws, allowing local legislatures to set their own hard boundaries. In New York, a bill that passed the legislature unanimously is waiting for the governor's signature. It would give the Attorney General the power to levy $25,000 fines for every single violation of the state's chatbot safety standards. Rhode Island has gone even further, enacting the nation's first outright ban on the practice of AI therapy by unlicensed entities, effectively foreclosing the medical use of chatbots for its residents. While Washington debates broad definitions, individual cabinet secretaries and state legislatures are already wielding kill switches and massive fines to enforce hard borders today. Understanding these models also means knowing what is inside them. An investigation by Endpoints News has now divided the mental health AI market into two distinct training camps. On one side, vendors like Talkspace and Lyra Health train their AI on transcripts of actual human therapy sessions. The model learns by ingesting real conversations between licensed providers and their clients. On the other side, consumer vendors like Headspace and Jiminy Health take the opposite approach. Their models are trained on synthetic data, conversations generated entirely by other machines to simulate human interaction. Neither federal nor state law currently dictates whose therapy hours are used to build these models. But for the clinicians who must provide informed consent, knowing whether the model was trained on a real human or a simulation is now a fundamental requirement. To navigate this era of new documentation and sudden liability, industry practitioners have produced the first operational manual for the field, a book titled Therapist in the Loop. The book introduces a framework called the triad. It argues that in modern practice, there are three active entities in the room: the client, the therapist, and the machine, and that their relationship is legally interdependent. This framework forces the human clinician to remain the party legally accountable for the machine's output, directly rebutting tech vendor claims that these models can operate with full autonomy. Between a federal floor vote, a documented contractor leak, and new state bans, not a single player in the AI space remains silent this week. The period of operating without oversight has been replaced by a paper trail of legislative votes, executive orders, and internal corporate records. The documents have arrived. It is now up to every founder, investor, and clinician to decide which of these new records they will use to navigate the coming era of enforcement.